is Father Shawn. He is a canon lawyer and a priest for the Archdiocese of Kansas City. He graduated right here from KU in 2003 from the School of Engineering. And in 2016, he got his canon law, I think it's called licentiate from the Catholic University in DC. He's on the Metropolitan Tribunal. Previously as a defender of the bond, now as a judge. So you can ask him all of your remaining canon law questions that you've ever had. An associate pastor of St. Michael the Archangel Church, and he's also a Scout chaplain. So.
Awesome. Thanks, Diana. Good to be with you. I graduated from KU in 99, so I was the last class of the millennium here. So my friends and I, when we talk, we actually sometimes get confused and say we graduated from St. Lawrence. So the St. Lawrence Catholic Campus Center was a big part of my time here at KU. When I was not at the School of Engineering studying computer science, I was normally playing my trumpet in the marching band and concert band and basketball band and things. And so I still come back over Christmas every now and then when the director needs a trumpet for when the students are gone for Allen Fieldhouse. So I do that. And then, so after that, I was a software engineer for a bit. So I went out and had a real job in the world, worked for Sprint for 4 years. But one of those things God kind of keeps calling. So I always want to say yes to God. And eventually he got through, and I went off to seminary in Chicago for 5 years and was ordained in 2008. So I've been a priest almost 11 years now, and all my life pretty much here in Kansas. So good to be back with you. And canon law was not something that I actually chose to pursue exactly. One does not become a priest thinking, I think I'll be a priest so I can be a lawyer. It doesn't quite work that way, but one of those things where I had, in seminary, I got a Sacred Theology Baccalaureate and a Master's of Divinity. Kind of thought I was done there, but then I got an advanced degree called a Licentiate in Sacred Theology. And I thought I was done there, having written another thesis, and then the Archbishop decided, hey, you could write a thesis. I need somebody who can write a thesis in law. So he sent me off to Washington, D.C., to the Catholic University of America, where in 2016, graduated with a J.C.L, Licentiate in Canon Law. So a lot of people will wonder just, okay, what does a canon lawyer do? Canon law meaning the law of the church. Maybe just to give me an idea where we're at on the civil side, how many 1Ls? 2? 3? Okay, so we're 1s and 2s. So that'll give me a little idea of how much civil law I get into. And in some cases, you will know more than me about civil law, even as a 1L. Because in canon law, we take a few civil law classes, especially on the things where there's some overlap between civil law and canon law. Marriage, which we're going to talk about today, being one of those things, but also things you might not think about, like the canon law of the church is actually a complete legal system. So there's penal law in the church, there's temporal goods, property law in the church, and so lots of different things, as well as the things you might expect, like the governance of the sacraments and things like that. But the church being a billion-member organization around the world, to have one legal code that fits all that is actually really quite an impressive accomplishment. And people don't often realize that the code of canon law, so that itself might be something you haven't heard a whole lot about. There is a code of law that governs the church, which we call the Code of Canon Law. We didn't actually have a Code of Canon Law in the church until 1917. Before that, the way the law was done in the church is Pope or councils or people would make law, just like a legislator would make law today in the civil sense. But the Pope might make a law that says X, and it exists in his papal pronouncement, and that's it. And then about the time 1917 came around, people said there are a lot of little laws floating around all over the place. Like, you have to know that, well, actually Pius VIII way back here said that, so that's the law. Well, but then no, actually Pius XII undid Pius VIII, and so you need to know about him. And someone said, why don't we just put it all in one book? And so one man actually got the task to kind of help do that. His name is Cardinal Gaspari, and so he created the 1917 Code of Canon Law to assemble the various laws of the church. And then in 1983, under St. John Paul II, we got a new Code of Canon Law based on some of the teachings of Vatican II that as you'll see, canon law is very much applied theology. So Vatican II, it kind of helped us hone some of our theological thinking, so necessarily law changed to fit the new thinking in Vatican II, and especially you'll see with marriage law, our theology of what we thought about marriage definitely kind of shifted at Vatican II. So you'll see that the law also changed. It used to be that, and it still is to some extent, that marriage law in the church is very much rooted in contract law. So maybe not as much of a theological kind of background, but very much based on contracts and what is being contracted, who are the parties to the contract, how is the contract brought about, and in the case of marriage, can that contract even be broken, and if so, by whom? And so especially we see, for instance, in the previous theological legal understanding, well, the subjects of the contract are, of course, the bride and groom, but what is being handed over and received was primarily considered with the rights of the body, the law in corpus, the use in corpus, the right to the body. This is the substance of the contract. I give my right of my body to you, you accept that, you also give the rights of the use of your body to me, and that is the substance of the contract of marriage, which is, of course, then ordered to our children. Well, somehow, brides and grooms didn't much like thinking of surrendering the contractual rights to their body in marriage. It's not so romantic. It's also not very personal. So under especially the theology after Vatican II, we focus a lot more personalistically on what brings about marriage. And particularly today, I'm going to try to look at some of the differences then between what we have in the church with regards to the canonical law on marriage, as that would contrast with what we know from civil law. So civil law today, marriage still very much based in contractual law. In fact, disparagingly so, to the point where, I mean, what are parties actually even agreeing to when they enter a civil marriage? I mean, it used to be that if there's one thing you knew about what does it mean to get married, civilly at least, it was that it's permanent. That this is a forever until death do us part kind of thing. In fact, almost every marriage vows outside the Catholic Church with no religious context at all would say, something about until death do us part, that marriage was intended to be permanent. Sadly, today, our civil law no longer backs this up, and you can drop your spouse almost as quickly as you change your boyfriend or girlfriend today. And that has proven to have very tragic consequences for all of Western society. It occurs to me that it was this day, actually, 3 years ago in 2016, where at this very moment I was attending the funeral of Supreme Court Justice Antonin Scalia. I was in Washington at the time, and I'd like to give prayers for the repose of his soul and for his family. And there's someone that really not only championed marriage and what that means in the law, but lived it out beautifully. And so we pray for the intercession and repose of the soul of Antonin Scalia today as we talk about marriage and law, especially in the church. A great member of the St. Thomas More Law Society there in D.C. and a great supporter of Catholic law and thought. So marriage law in the church then, we still hold that incredible notion that we think we should hold people to what they say on their wedding day, meaning that two people come before God and they ask God to please bind them together in a way that is so permanent that neither of the two parties can actually break the contract. So when we talk about, how do Catholics get out of their marriage, or, we talk about annulments as they're so called today, keep in mind that we're starting with two people who come before God, in the case of a Catholic marriage in the church, and actually ask God, please do something permanent here. We want to bind ourselves freely, choosing together in a way that is so permanent that neither one of us will have the option to end what the church now no longer calls a contract, but a sacred covenant. And when we use the word covenant now after Vatican II to deliberately talk about language that speaks of the kind of covenants that God made with his people in the Old Testament. These are permanent family bonds that get created. And even if we think civilly, one of the key reasons for the civil permanence of marriage is to pair children with their parents. What you might ask, why does the state have an interest in marriage at all? If marriage is just about who loves who, well, I can love my dog. I might love pizza, which is really tempting sitting over there. And we use the word love all the time. Why would the state even care about love? If we're legislating love, that seems hopelessly ridiculous. Well, the state has an interest in marriage because marriage is where children come from. And so the state has a vested interest in saying we want to make sure that children that are born have parents to raise them so that the state doesn't have to raise them. Of course, studying Western civilization, we also know that the family is the building block of all society. So if we want a strong system of government and legal system, we need strong families and people that are predisposed to obey the rules, not because we make laws that force them, but because there's a God who is just. So we see that civilly, we've kind of been let down a little bit by marriage law. One can even ask, what does it even mean to be married civilly today if it's entered into and gotten out of like a housing contract or something? Church is a little bit different. I'm going to focus my talk today around just one canon in the code, and that is Canon 1057, if you ever want to look this up. And it gives us what I want to focus kind of on three aspects of marriage in the church today as to what brings it about and therefore what might end it. So it says the consent of the parties legitimately manifested between persons qualified by law makes marriage. And I'm going to draw your attention to three important things. Consent, legitimately manifested by persons qualified by law. These three aspects of marriage, it sounds pretty technical. We're talking law here, so I'm not going to go over some of the more personalistic things that a lot of times law in canon law after the 83 code now will state kind of theological canons like, it is to come together to form a total partnership of life and love between a man and a woman. And that's all great, and it's theology, but it doesn't do a whole lot for us legally as far as, well, what are the nuts and bolts of what really makes marriage, and therefore what might end marriage. So consent, legitimately manifested, those qualified by law. So I think most of us know now that it is possible in the church for the church to say that two people who stand up before God, even perhaps two Catholics, before a priest in a solemn ceremony in the church, who recite their wedding vows and promise to be married to each other forever, that what looks like a valid marriage to all intents and purposes and would be a civilly legal marriage probably, in fact, was not a valid marriage. And that's where my job as a canon lawyer, as a judge on the marriage tribunal comes in, that people will bring a legal case to challenge the validity of their marriage bond, to say that on their wedding day, what looked like a marriage, in fact, lacked something on each of these three elements. So what we do in the marriage tribunal, it is an actual court. So it would have all the things that a normal court would have. So normally you have a college of 3 judges who will judge the case. Decisions don't have to be unanimous. You can have 2-to-1 decisions on a marriage nullity trial. You will have the parties to the case, which are the husband, the wife, who are challenging, and only they have the ability to challenge their marriage. Their intended spouse can't say, I'm going to challenge the marriage of these people so I can marry them. It's got to be one of the two parties, or there's an official of the court known as the promoter of justice, which is kind of like the county prosecutor, if you will, who has the right on behalf of the church to challenge a marriage. Then you have a notary, as you might imagine, and then the final party to the case is a court-appointed officer known as the defender of the bond. Now, this person is a canon lawyer who would otherwise probably be qualified to be a judge, for instance, or an advocate. But their role as defender of the bond is to make arguments in favor of the validity of the marriage during the trial. Because if you think about it, the parties to a legal action, normally you have, someone who is the petitioner bringing the case, and then the respondent is opposing the petitioner, and you have a contentious trial between the two parties. However, in a marriage nullity trial, you might often have both parties seeking a declaration of nullity of the marriage. So both the husband and the wife are going to argue the side of the case in favor of invalidity. So the church figured out in about the 15th century that, to maintain the solemnity of the bond of marriage, we need somebody legally qualified to argue the other side of the case. So the defender of the bond is a court-appointed attorney to make all legitimate arguments in favor of the validity of the bond of marriage. So that's kind of the dynamics of the trial. Now, it's not as exciting as you would think. People, they actually made a movie recently called The Tribunal, where it's like real dynamic, and they're like, before judges, and they're Catholics and dressed as priests, and you've got all this drama. Yeah, I took a picture of my desk in the Archdiocese and Chancery office. It's a pile of folders, really. I mean, that's the drama. I get the case file on my desk, and I normally never meet any people involved in the case. Now, I like to actually meet people myself or talk to them, so I will often, send additional questions or try to meet with a party perhaps. But the way it normally works, we send out affidavits, they sign, give us our testimony, and then I've got a case file full of the testimony, and as a judge, I go through that. The defender of the bond intervenes after having seen the evidence, and then I meet with the other judges to make a decision. So it's not all that dramatic. There's not like you have both spouses and they're yelling at each other. That would get too dramatic, and that's why the church doesn't do that. Because as they found with divorce courts sometimes, there's a reason why they could have a TV channel about that. It's a little too dramatic, and the church is in the business of healing as much as we are about getting to the truth, and having husband and wife slug it out before a priest is not always the best thing. So that's the way the trial aspect of it works. And so what's on trial is actually the bond of marriage. The question that is always before the court is the invalidity of this marriage known with moral certitude? And the decision will be either affirmative or negative. Is the invalidity of the marriage proven? And at the end, the judges are going to say, yes, we have moral certitude. So probably you've learned about different standards of certitude, and sure, there's preponderance of evidence and beyond a reasonable doubt. Moral certitude is beyond that. So the church is really serious that we're not going to say a marriage is invalid unless we have certitude that it was. So it's a pretty high standard. What we're going to be looking for in the trial is deficiencies in one of these three things. I'm going to start with the qualified by law part. What would it mean for someone to not be qualified to be married? So we could say that someone's marriage was null because although they stood up before God and all the people in the church, one of them was not qualified to enter into this covenant contract. Some examples of what would make someone disqualified. These things we will call impediments. Well, for instance, if you are related to the person you're marrying, consanguinity, something that civil law actually does still care a little bit about today. You can't marry your brother or sister. You can't marry your mom. You can't marry your son or daughter in the direct line. And then the line of affinity with marriages, you can't marry someone up to the 4th degree of affinity. So if you are within that, you are disqualified from marriage. Likewise, people who you might not expect a disqualifying thing, impotence. If people are not able to engage and complete the sexual act, that's important for us in the sacramental system that involves physical things. It's not just about feelings. It is actually required that you be able to perform the marriage act. If you are permanently and antecedently impotent, you are disqualified from marriage in the church. So there's something that people might not even be aware of. And there are various other impediments. One of the big ones is you can't already be married to someone else. That's why we have this whole process, because unlike society that says, if you're married, just get that thing divorced and then you go marry somebody else, it's actually an impediment to marriage to be married to somebody else. So it doesn't matter if you do all the right things. If you're already married, it's automatically null. And this isn't too hard to figure out, but there is a possibility, and this does happen, where someone was actually married to somebody else and they didn't bother to tell the person they wanted to marry now, and it comes out that, they were already married. So having a prior marriage bond is a disqualifier to entering new valid marriage. And there are various other things like being a priest. I am disqualified as a cleric from entering marriage. And for people that know that, like we have in the Catholic Church, we have what we call permanent deacons, for instance, who are married and are ordained deacons. They are actually also disqualified from entering marriage as a deacon because they are a cleric. That means that if a permanent deacon is married when they're ordained and their wife should die, they can't remarry. Clerics are not able to validly marry in the church. They are disqualified. So those are some of the what we call deriment or disqualifying impediments that make someone unqualified. Then, briefly, legitimately manifested. Okay, let's say that you are in fact qualified to be married and you're going to properly consent. Well, we have a problem if two people who meet these categories, as we colloquially talk about going back behind the barn and saying, do you want to marry me? Yeah, I want to marry you, because if you don't marry me, then I don't want to have relations with you. But if I marry you, then it'd be okay if we have sex. So clandestine marriages, people who, how do we know that the exchange of consent has happened? And so this is a problem the church had to deal with. Just two young lovers decide, I want to marry you? Yeah, I want to marry you. Let's do it. Okay, we're married. And they exchange consent. There's nobody there. All right? Or people marry multiple people in different ports before we had mass communication. I married you in this port, but when I'm traveling over to this port, well, it's a month's ship's journey away, and I'm married to somebody else over there. So we have a problem of knowing, okay, when is this consent manifested? And so the church has come up with, for Catholics anyway, what we would call canonical form. The form of marriage. So Catholics are bound by the laws of the church, and the church has said, in order for this consent to be legitimately manifested, you have to manifest consent in canonical form, which means before a priest or deacon or bishop and two witnesses. Okay? So that's when you hear sometimes people, their marriage is invalid because they got married, quote, outside the church. That means they got married outside of canonical form. Often this would mean that someone who is a Catholic, bound by the laws of the church, rather than exchanging consent before a priest and two witnesses, goes to the justice of the peace, goes to a judge, goes to a flying Elvis impersonator in Vegas. Okay, well, society would consider that legitimately manifested. Yeah, if you've got your little marriage license and contract, who cares if it was a flying Elvis in Vegas? It's legit. Not so in the Catholic Church. We require a little bit more. For Catholics, has to be before priest, deacon, bishop, and two witnesses. That is what we call canonical form. So that way we know that, yes, they're qualified, because we'll do some checking then to see, are there any of these impediments? And then we know that it's legitimately manifested. If you get married in the Catholic Church, notification will be sent to the place of your baptism where your church record is at. And they will note on your baptismal record, so-and-so got married to so-and-so on this date, so that there is a permanent record. And it is kind of important that we know who's married to who. So that's what that's about. So sometimes our canonical work will be to declare a marriage null because it was not done in canonical form. So these are so-called defective form or lack of form cases. We use a shorter process on those called a documentary process because all we really need is the documents. Yes, here's a baptismal certificate, says they're Catholic. Here's a marriage license showing they got married by a flying Elvis. This is null due to lack of form. So we do a lot of those, as you might imagine, with Catholics these days, thinking, oh, I'll go to a beach and get married and it'll be really nice. No, Catholics are bound to be married, quote unquote, in the church, in canonical form. So it's not just that it's not as good if you get married on a beach, it's not valid unless you get the laws dispensed in your case. So I am amazed the number of young Catholics who don't realize this, who found out later, like, what do you mean my flying Elvis wedding wasn't valid? Or, you know, we all went down to Mexico, to Puerto Vallarta, and we got married on a beach. It was so lovely. Like, yeah, it was a nice little ceremony, but it wasn't valid. So to correct that, we'll have exchange of consent in canonical form. Sometimes we call this a convalidation, when two people are not validly married and the thing that's missing is just the legitimate manifestation. We'll have them come before a priest and two witnesses and legitimately manifest their consent, and now they're married. Okay, the one that takes the most amount of time in my work as a judge and for marriage tribunals is a defect of consent. Because this gets a little bit harder to prove. And so these are longer cases, because here are some things that might affect consent. Well, we're going to look at psychological issues. Did they say, yes, I intend to be married to this person forever, but in fact, in their mind, they were suffering from a psychological illness that prevented them from making a sound decision? Okay, well, they can't be held responsible for a decision that they couldn't make because their reason isn't functioning. Or maybe they reason that I really want to be married, and so I consent to be married, but they're not capable of it because they're addicted to something, and they're not free to make that consent. They're consenting to something they can't do. So that could disqualify them. Then the main reasons for consent being invalid, I'll draw a parallel to these. So we have permanent exclusivity and children. So you have to consent to a marriage that is permanent forever, that is only between you two, and is open to children. If you deliberately exclude one of those three things from your consent, I want to marry you, cross my fingers, but I'm really not going to have kids with you. Okay, well, we call these, the positive exclusion of one of these, we call this simulation. If you positively exclude one of those things, you have simulated your consent. You're saying, yes, I give myself to you permanently forever and I want children with you, but I'm keeping my girlfriend, just in case. Well, okay, you've said only you, but essentially you lied. You're saying, yeah, only you, but her too. Yeah, I want him too. And, so this would invalidate consent because what looked like consent was actually not consent. It was a false eloquium, a mental reservation, a lie. But sometimes people don't deliberately lie, but they do willfully exclude. So this is the area where we see probably most of the kind of cases for annulment, this so-called simulation. And sometimes simulation is just total. Like someone only pretended to get married for immigration reasons, for instance. Like, okay, will you marry me so I can stay in the country? Yes. And so they exchanged consent and it looks like a marriage, but it really wasn't because both of them excluded marriage altogether and said, we're only doing this for the civil effects of immigration status or something like that. These are the kind of things that we're looking at in a marriage nullity trial. There are also the possibility that rather than positively excluding these things, people were in error. that people really didn't know that marriage was supposed to be permanent. Now, that seems kind of far-fetched, but in our society today, we do have to weigh the fact that, well, if you come from a divorced family, everyone you know around you is divorced, and you see people all the time get up and say, yes, I marry you forever, and then later get divorced, it can induce error in people to think that, well, yeah, marriage is permanent in that you do it until you don't want to anymore. Well, that's an error. That's not true. Marriage is permanent. We say the bond of marriage is indissoluble. It is permanent. So if you don't realize that, or are sure that it's not permanent, you could be in error, and your error could invalidate. And then there's kind of the Shakespeare consent invalidation, where you marry the wrong person. Now, I always wonder how this happens today, but ironically it happens in Shakespeare all the time, where you marry someone who you think is her sister, turns out it's not, and, well, this happens in the Bible too, with Leah and everything. So it is actually a defective consent. It's called an error of person, if the person you marry is in fact not the person you intended to marry. Now, in our romanticized Western version of marriage, that seems pretty hard, but imagine in a country where marriage is arranged and the parents have brokered a deal for you to marry someone, and at the last minute they substitute someone else. Now we see back to contractual law that's in here, like, I didn't get what I paid for. Okay, I ordered a new Aqueduct on Amazon, and you gave me this Google thing, and that's not what I wanted, so it's the wrong thing. Well, that can happen in marriage, and it invalidates a contract like a contract. We don't normally see an actual error of person, but what we will sometimes see is an error of quality. So there might be some quality in a person that you are so attached to that you want this in your spouse almost more than you want that particular person. I want to marry an engineer. And I don't even care as much who it is, but it has to be an engineer. Okay, and engineers were pretty attractive, you can imagine. But if someone really says, I only marry an engineer, and I found this great guy, and he's an engineer, and it turns out he lied about being an engineer, well, it could be then that, especially if the person, when they find out it's not an engineer, I'm out of here, that's not who I married. So it's an error of quality that we can say redounds to an error of person. The quality is so important that it's almost like you married the wrong person under false pretenses. Lying about a serious matter to obtain consent also could impel consent to the point that it would be invalid. And there are a number of other different things that could make consent, in fact, invalid. So what we're looking at is to put all this together, and then at the end we pronounce a sentence, and the sentence will either be affirmative or negative. Yes, the nullity of the marriage is proven, affirmative, or no, it's not proven. There is no declaration of validity. Okay? At no time will the court say, we've examined the evidence and we pronounce that this marriage is valid. We will simply say, either we're able to prove that it's not valid, or we were not able to prove that it's not valid. We're never asking the question, is this marriage valid? So it seems like a legal semantic thing, but it's important to remember that in the church, the bond of marriage enjoys the favor of the law. So we start with what is a legal presumption, if you've studied those. The presumption is that this marriage enjoys the favor of the law. We call it a putative marriage. And the trial is to prove that that is not true, to overturn the presumption. So the best you're going to get from this is if there's a negative decision, it says we weren't able to reach moral certitude that this is null. It might be, but based on the evidence that was presented to us, and maybe it's not null because we couldn't get any witnesses to testify, or that there just wasn't enough evidence left to talk about it, because we're only concerned about what happened at the time of consent. Notice that this is all on the day of the marriage. We don't care that your spouse became a real schmuck 20 years down the road. If on the day of the wedding your spouse intended exclusivity, fidelity, and then 20 years later got tired of her spouse and she goes off and commits adultery, adultery does not invalidate your marriage. No, she's not faithful. She's not being exclusive. But if she intended on the wedding day to exchange proper consent that I intend to be faithful, then what happened after that is up to you. God will give you the grace in the sacrament of marriage to live out your marriage. What you do with that is going to be up to you. And now that the church does have a process in the case of like danger that one person, say, is abusing the other person physically or mentally, emotionally, the church allows a separation with the bond remaining. Because it may be that you're validly married and you just can't live together anymore because it's not safe. The church allows the couple to move apart, and there can actually be a process you can go through to get permission to move apart even though you're married. All right, that's a real kind of 1,000-foot pass of some of our work in the tribunal and what we do. There's a lot of things that you can hear that sound a lot like a normal civil kind of trial. There's evidence, there's standards of evidence in canon law that says what is admissible and what weight this is to be given, and can the judge consider this, and what evidence level is a testimony versus a document, and it gets pretty technical. It's a 3-year law degree. I always feel kind of bad. You go to law school for 3 years and no one even knows what a J.C.L. is. Well, that's because you guys go to school for 3 years and you get a D after your name. That I'm a doctor of the law, the Juris Doctor. Well, I got a 3-year law degree too. It doesn't have the D after it. Because in the church, if you want a doctorate in the law, it means you want to teach law basically, and so you go and write a dissertation. But that's all I'm going to say on that. And I love questions, so we'll open it up and see what you guys actually want to talk about. Okay, yes.
So one of the questions that I have had about canon lawyers, are canon lawyers bound by like the same sort of duties of like attorney-client privilege or confidentiality that you would normally see for lawyers?
Great question. So she's asking about attorney-client privilege, things like that. That was one of my first questions that I ran into in practice, because that canon law does talk about the secrecy of the tribunal. So yes, the judges and the officials of the court are bound by secrecy in the law. But I wondered, how that translates. Am I protected under civil attorney-client privilege statutes? And I'm not sure. I think the way it ends up working is that there's the civil law recognizes a minister relationship. So it's not so much that attorney-client privilege covers me, but it will be seen as this is a religious counseling kind of thing, and it's protected under that, at least in America. Now, in other countries, the canonical lawyers are on the same level as other attorneys. Because, for instance, if you bring a marriage nullity trial in Italy, and the court finds in favor of nullity, that's a civil divorce. It has effect in civil law as well. Here in America, they kind of think, well, you Catholics and your tribunals are just kind of playing around. So you do whatever you want. It doesn't have any civil effect. But I'd like to think that attorney-client privilege, most of the lawyers that are involved, we would operate under that presumption, but the actual civil law that protects it, it would be an interesting court case to bring to see if attorney-client privilege covers canonical advocates.
Thank you, Father Shawn. That was great. I often get, Matthew 19, exception clause. So he who marries is married and is adultery with another or sleeps with another, except for porneia in Greek, commits adultery. And it's very frustrating because even I just searched on Google Matthew 19, and the translation King James is that except for sexual immorality, which is a terrible translation because porneia goes back to Leviticus 18, which is condemning the type
incestuous kind of
relationship. So it's not saying that if your spouse is unfaithful, that disqualifies the marriage. No, right. As you're saying, then the marriage never existed in the first place. Yeah. And so it wasn't a valid marriage, and therefore when you leave that marriage, it's not adultery. I think this is the most commonly misunderstood.
And sometimes even the language that we use, I do it too because people understand it when I say annulment. People know what we're talking about in the church, annulment. The problem that postfix meant on the end of it's a verbal kind of thing. As in a verb, and that it applies some kind of action. Like annulment seems to imply the act of making null. And that's really not what we're doing in the tribunal. We are declaring that this putative marriage, what looked like a marriage, in fact never was. We don't make a marriage null. We are investigating to see if it was null. So that's an important distinction. It's not like you go to your civil attorney to get your civil divorce, and then you go to the Catholic tribunal to get your Catholic divorce. This is not divorce. We are not ending a valid, consummated marriage. No power on earth can end a valid, sacramental, consummated marriage. No power can do that. Only death ends that. And it's interesting, that little exception clause in Matthew where he says, he who divorces his wife and marries another commits adultery unless, porneia in Greek. Well, that's a lot like this qualified by law thing is what they're really saying. They're saying unless one of the parties was not qualified by law, and particularly there, as Luke is pointing out, it was really referring to a marriage between two close of consanguinity at that time. That would have been an abomination, a porneia, from which we get the word pornography today. So it's not just sexual immorality. It's divorce, it's adultery, unless, the person was cheating on you, or unless she didn't cook very well, which was actually grounds in Leviticus sometimes for putting away your wife. So, we've come a long ways. Yeah.
Disclaimer, I'm not Catholic, but I'm...
Oh, great. Welcome. Yeah, awesome.
I'd be interested, because I'm wrestling with this too, the Catholic Church's position on lawyers, JD lawyers, who handle civil divorces. In other words, I'm the #1 divorce attorney in Kansas, and come to me and I'll get you a great deal.
Yeah, and this is a problem for Catholic lawyers all the time. They're involved not just in, say, divorce, but always we're looking at ethical questions as to, okay, can I be involved in this? And I do go back to Thomas More, who our society here is named after, who said he would give the devil the benefit of law if it would protect him. So there is a sense in which practicing the craft of law and assuring that the laws of the state are applied in a just and equitable manner is itself a noble thing. So we have divorce laws in our country, and there's nothing wrong with a Catholic trying to make sure that perhaps those laws are applied in the most best and equitable way possible, and realize that the Catholic Church will recognize and allow civil divorce, that it would end the common life of two parties and perhaps take care of asset division and child custody. Notice my job in the tribunal, I'm not deciding child custody issues, and for the most part, not asset division. So those are all things that happen through the civil process of divorce. Where the Catholic Church steps in and has a problem is to say, divorce, although it might end the common life of two parties and take care of worldly problems, it does not end the bond of marriage. So there are cases where the church would say divorce is okay, even for Catholics, but you are not free then to enter a new marriage as if you're not married. You are married unless a canonical process shows that in fact you were never married. So I can definitely see that a Catholic could be maybe using their talents as a lawyer to even try to help reconcile parties. It actually was in the Code of Canon Law until very recently when Pope Francis changed it, that the judge on the tribunal had an obligation to try to help the parties reconcile before we would try to see if their marriage was null. He took that out, Pope Francis did recently, and now it's actually required before we begin the marriage nullity trial that all hope for reconciliation is actually passed. And we normally use a civil divorce as an indication of that. So as with all things, it's not black and white. So if I'm a Catholic and a religious person or just a moral person, I don't want to be like a divorce ambulance chaser out there trying to, let's see, let's see if I can find a marriage that's not going very well, and I'm going to do what I can to break it up, and, that's not going to go well with God. But to the extent that, maybe one spouse is being abused and needs to get out and separate, well, they need a good lawyer to help them with that. So as with law and any profession, really, we as Catholics, when we're in the world, we want to be leaven to the world. We want to make it better, and so we're involved in a lot of things that would otherwise be neutral, perhaps, and there's going to be opportunities to say, okay, this is really pulling me to do something that I think is immoral, whereas maybe I can be in there and I can change the dynamic a little bit. Maybe Catholics being involved in all parts of the world will actually make it better. So, yeah. Okay, yeah.
Well, I understand that if you get a divorce, a civil divorce, and then you don't follow through with the Catholic Church, that you will not be able to get married again in the Catholic Church. What other effects would that have on that couple?
Okay, so yeah, if you get civilly divorced, many people don't realize that just being civilly divorced does not mean that you can't receive communion. It doesn't mean you're living in sin. There was a time when just getting divorced wound you up excommunicated, but that's no longer the case. So, like I said, there may be good reasons why couples have to divorce. Where Catholics get in trouble is when they then try to enter a new marriage and live as though they're married with someone to whom they are not married. Okay, so if I get civilly divorced, maybe it's not no fault of mine. Maybe my spouse left and they divorced me, and with no fault divorce, there's nothing I can do about it. You're not living in sin. You're probably going to suffer a lot, and it's not anything you wanted. It's when you then say, I'm going to go attempt another marriage, and you'll know it's not valid because if you tried to do it in the church, in canonical form, we're going to say, well, we need to look at this other bond that you've got to see if you are maybe disqualified by a prior bond. If you don't do that, and you then get married before a judge or on the beach, before an Elvis, whatever, that marriage is not valid. And so you are living as though you're married with someone to whom you're not, and we call that adultery, objectively speaking. Regardless of the feelings or the commitment, objectively speaking, you are engaging in marital relations with someone who is not your spouse. We call that adultery, and that disqualifies you from receiving communion because you are likely not in a state of grace, or at the very least would give scandal. So that's how that operates.
Time to change your action, got it.
Yeah.
I have maybe one last question. We're going on time. But it seems like someone might say, well, it seems like you could make up any excuse, basically. You could always argue that, well, you didn't really intend to have children. And so it looks like it might be a slippery slope. Indeed, anything could have been bothering you that day when you gave your consent at the wedding. You didn't really mean it. So what type of evidence could be presented?
Right. So a lot of times we are looking for the same kind of evidence that a civil court would want. And so, we see tons of these marriage cases, and sometimes people know, like, just say you didn't want children. Okay, well, what evidence is there of that? Do we have statements outside of a suspect context? Do we have statements made by the party at a non-suspect time that would corroborate this? Like, before the wedding, the bride told her best friend, well, there's no way I'm having kids, though. I'll do this Catholic thing, so whatever, but I don't want kids. Do we have that? Is that in an email? We're looking for serious evidence here. Remember, our standard to find an affirmative is moral certitude. So someone telling me, yeah, I didn't really want children when we got married, that's not going to do it. That people can say that, but even if it's true, what evidence is there? And if there's not evidence, it may in fact be that she really excluded children. But can I accept just one person's testimony, especially now at a suspect time of a trial when they want their marriage to be declared null? Does that give me moral certitude that in fact there was an exclusion of children? No. But if I've got an email to a sister at the time of the marriage when she really wanted to be married but admits she's excluding, or we have evidence of there was another relationship going on which the person didn't end. Multiple witnesses attest to this, and there's other evidence. Now it's starting to get me towards moral certitude. So it's going to be whatever kind of evidence is going to cause me as a normal, rational thinking person to have moral certitude as to what is being asserted. And that may take a bit of evidence. In the case of the psychological things under consent, like, we actually are required to involve a court expert who is a psychologist to say, all right, this person is claiming they had this disease. Can you look at the evidence? Tell us what effect this would have had on consent. Were they free to exchange consent? This particular psychological illness, because I'm not a psychologist, so I'll get a court expert to testify and tell us this is the effect it would have had on consent. Based on their medical history, they would not have been able to be free to consent, and therefore that will be evidence that will lead me towards moral certitude. There's supposed to be a pretty high bar. Now, point of fact, especially in America, a lot of marriages get declared null, like an enormously high percentage. And that's something where we're talking about, like, even my profession as a priest, as a canonist, am I being pressured by people who really want their marriage to be null, especially if there's only one party involved? Like, the man really wants his marriage null, the ex-wife doesn't care, she's married to somebody else. The only line of defense there is the defender of the bond, who's supposed to make a good argument that marriage is valid. But I always tell people, a lot of times when I was the defender of the bond, and I'm the one arguing for the validity of the marriage, I'm like, the only people who are going to be happy if I do my job really well is Jesus. Because the spouse is going to hate me, and the judges are going to hate me, because there's a real pressure. Look how easily we do civil divorce today. And so, is there pressure to do the wrong thing? Yeah, especially as a canonist. Not that I would deliberately do the wrong thing, but I know my life is a heck of a lot easier if I just say affirmative. Yeah, affirmative, affirmative. If we give 100% affirmatives, it's likely no one will ever complain. But you give a negative, now people are appealing to the second instance, or maybe to Rome, to the Vatican, and they're like, why is this slowed down? And the bishop wants to know, why is it taking so long? You know, maybe I'll leave you with this image to kind of help you see what we do. I look at it as a little bit like instant replay, say in the NFL, those of you that are familiar. So a play happens, there's a call on the field. That's a completed pass. Okay, they throw their little red flag. They think, I'm going to challenge it. I think it hit the ground. All right, so the replay official goes over, looks at the replay. Imagine if that replay official was given 10 seconds to look at that replay. What do we know about instant replay in the NFL? Well, if you don't know, the call on the field stands unless there is irrefutable evidence to show that it was the wrong call. So two things can happen. They could affirm the call on the field, it was the right one. We won't actually do that in a marriage nullity case. We don't do proclamations of validity. Or they could say the call on the field stands because we just can't see enough evidence. Or they could say we've seen the evidence and in fact we're going to reverse it. Well, if they've only got 10 seconds, you go over, you look at it, they see one angle, I can't tell, I don't see it hit the ground, so call on the field stands. All right, so you give them 20 seconds, all right? Yeah, I don't see it, give me another angle. Oh, now that might have hit the ground, I'm out of time, I didn't get enough evidence. Sorry, call on the field stands. Now imagine you give them 2 minutes to look over and like, boy, it looks like it hits the ground. Show me from up above. No, okay. Show me, there. Yes, I see the blade of grass. Hit the football. The football definitely hit the ground. Incomplete pass. The call is overturned. Put that in the marriage nullity context. If people want their annulments fast, they want it done quick, that is more likely to end up in more call on the field stands. In other words, the call on the field is that the marriage is valid. Marriage enjoys the favor of the law. It is presumed valid unless shown otherwise. So if we just do a quick job at it, we're going to have to say, yeah, I don't have enough evidence to have moral certitude. This is so call in the field stands, negative. Nullity is not proven. It's actually a matter of charity that we would take our time to look at all the evidence to try to say, okay, maybe one more witness. This witness gave me the thing I needed that the other ones didn't. Now I can say, yes, we're overturning the call of a presumptive valid marriage. It is, in fact, an affirmative decision. I am sure now this marriage is invalid. But it might take more time to get to that. So the shorter amount of time, the more negatives we should have. The longer amount of time we take, the more we're likely to get to the truth. And that's ultimately what the whole marriage nullity process is about. We're not looking to be nice to people. We're not looking to be merciful to people who really have a lousy spouse that they want to get remarried. We are looking for the truth. That's it. Was this marriage valid? Can we prove that it was not valid? That's it. Was the marriage proven beyond a moral certitude that it was invalid? That's it. That's all we care about. Whether that makes people happy or sad, I don't know. But that's what we're about. We're about the truth of the matter. And from there, we just have to give pastoral care to help people with the truth. And how much better our society would be today if we did that. Rather than lie to people, rather than try to make people have their own truth. If we just helped people know this is true, and now let's help you live out that truth. Which might mean that you're married to someone who is no longer a very good person you can't live with. But if that's true, God will help you get through that. But it also provides great kind of reassurance for people whose marriages did break down to know that, in fact, it wasn't valid from the beginning. Your spouse lied to you. Your spouse withheld something. Maybe the reason it didn't work out was because it wasn't valid. And that's also a good truth to be able to share with people.
Thank you.
All right, thank you very much. All right.
Thank you. Look online at the website if you're interested in the St. Scholarship. It'd be great to have you guys. Excellent.
I don't know quite what you're looking for there, so we'll see.